We're here live from Houston, Texas. Along with me is Emily Neumann, my business partner. We're going to discuss today about the CPT and all the issues regarding the CPT. Emily?
Hi, we're here from REDDY NEUMANN, PC. We're immigration attorneys. We've been practicing since 1997 exclusively in the area of employment-based immigration, and today we're here to talk about curricular practical training, which is a common way for non-immigrants in the United States to work while they're studying when they're on F1 visas. So we're going to be talking about what exactly is CPT, what are the right ways to do it, what are the wrong ways to do it, what are the consequences for those who obtain CPT where it may not be authorized, what is the long-term impact on your overall immigration journey. How does the Unlawful Presence memo that went into play on August 9th impact students who use this CPT? What options do you have? So to start off with, let's just start with the basics and define exactly what is CPT. It refers to Curricular Practical Training, which is a type of training that F1 students do before they graduate. Optional practical training is normally done after you graduate, so curricular practical training is before you graduate. It's defined in the immigration regulations specifically as a program that is alternative work study, an internship, cooperative education, or any other type of required internship or practicum that's offered by sponsoring employers through cooperative agreements with the school. That's the base requirement for any type of CPT. It's supposed to be work study. Notice I didn't say work/study, internship, cooperative education, again, education, or any other type of required program that's offered by an employer through an agreement with the school. We see a lot of times people getting CPT, and it's very common. Is there something inherently wrong with CPT? When is it normal? When should it normally be used?
There is nothing inherently, I don't think so CPT is inherently wrong, Emily. If the person is using it for the proper purposes for which you have described it in your initial statement, that it's part of the education that they require this experience. Now, and the training too. However, the way the concept is being used by some of the students at this point of time is not actually to be a part of the education, but they are using it as a work permit. And that's where we see a lot of stem of problems coming. When the H-1B extension has been filed, when change of status has been filed, the USCIS is questioning that how the student maintain the legal status when they are in the CPT, how are they allowed to work? Is it really a part of the work, the study program, or is it quite different? We have noticed that there are only some universities that are issuing these kind of CPTs, and the students who have no option to work, they have probably exhausted their STEM extension and they did not get into the H-1B. They are using this as a tool to work, not a tool to study, but a tool to work. And that's where the stem of problems are coming from the CPT. Now, Emily, you said that there are certain conditions only the CPT is allowed. How does a student obtain a CPT? I'm speaking of where they are supposed to be legally obtaining a CPT according to the regulations.
Right, so the regulations specifically say that CPT may be authorized after 1 year of full-time graduate studies. So typically, after 1 year of school, you might want to do an internship during your first summer. That is the perfect example of when CPT is proper. So at that point, you've met the requirements, you've met the 1 year requirement, you've already attended school for 1 year. Now, the purpose of the internship or the summer job is to apply what you learned during your first year in the classroom. So at that time, during the summer, yes, you can be authorized for CPT to do full-time work during the summer in order to apply the knowledge that you learned during your first year. Once classes come back in the fall, most people then study full-time and they don't work. There are some situations where you might do part-time CPT while you're studying, but it's very rare because most of the time, at least most schools, graduate school is not easy. I mean, you're meant to study, you're meant to work hard at the studies, and most people, if you're doing it right, you don't really have the time to work. You're focusing on your studies. Now, what we find is certain schools set up their program in such a way that the studying portion is very minimal, which allows someone to be able to work 40 hours a week and still somehow take classes. And that typically is very unusual. So for an example, in law school, which is a type of graduate school.
That you and I went to the same school?
Right, University of Houston here in Texas. They have a requirement that you must be in law school for 1 full year, and you cannot work during that first year. You have to only attend classes, and then after
were you on student visa, Emily?
No, and that was that was for citizens as well. It's not just something related to F1 student visas. So across the board, the school says no one can work during your first year of law school. That's the exact same situation we have for most schools, graduate schools in the United States. Your first year, you're there to learn, and then maybe in the summer you can apply that knowledge from the classroom into a real world working environment for the purpose of furthering your education. So now the question becomes, well, first let me just ask a basic question. If someone has CPT, is their status CPT? You hear all the time people say, yeah, I'm on CPT. Is that a thing?
No, there's nothing called CPT status. They are still on student visa status. It's never a CPT status. And the student visa clearly defines that they have to follow the regulations and rules prescribed for the student visa. So if they are following, just like the way when you are, even though you're a US citizen, I mean, you still have to follow those things that in the first year you're not allowed to go, and in the summer you're allowed to work. That's when you started working with this firm as a law clerk, and then graduated and became a lawyer here and became a partner. Now, obviously coming to the point that the CPT is not a status, they are supposed to be in a student visa, going through the regulations and all those things. Emily, the regulations are there, the rules are there, but the major question that pops up with the student is that I got the CPT from the university. That means I'm authorized to work. Why are you telling it's illegal when I have the authorization from the university saying that I'm authorized to work?
Well, we have seen USCIS make decisions later saying even though you have the authorization from the university, it was not properly authorized because it was not in line with the regulations. It was being used as a way to work, not for the purposes of study. So, yes, it may have been authorized by the school, but that authorization can be questioned later by USCIS, and it's happening more and more, especially in
You said it's happening more and more.
Yes, exactly, especially in the H-1B filing. So once you are converting from F1 into H-1B, of course, USCIS is going to be looking at, from the time you were on your student visa, have you properly maintained that status? And many times they are looking at CPT time and questioning, was it properly authorized? Now, a question I have for you is, in all of the laws and all of the regulations on student visas and immigration in general, is there any such term called Day 1 CPT?
No, there is nothing called Day 1 CPT. I think so. It's completely illegal to have a Day 1 CPT. I just cannot understand how it is legal with all the exceptions, with all the rules and regulations, it just is inconceivable to think that a student will be authorized on the day one that he joins the university, while you are telling that even for US citizens there are restrictions. You cannot work in first year of the law school. This is day one CPT. They're on the student visa. The regulations specifically prescribe a lot of things that are in there in the regulations that you initially cited. I don't think so the student is following any of these things in getting the day one CPT. Now, I understand why they are applying for it, because their STEM extension has expired, there's no option, they're applying for it. But legally, I don't think so day one CPT is legal at all. Now, also, Emily, some of these, the DSOs that are issuing the day one CPTs, they are not even conducting the classes. They are telling everything is online and the classes are once in a month, or some of the universities are issuing once in a semester. Now, I had some argument with some of these people, students, and say, well, right now there is an internet technology, there is a lot of technology that has improved. Distant learning is a normal thing. We do understand that the distant learning is a normal thing, but then you should have been in your home country. The purpose why you are in USA is that it's not that you are having a distant learning, you are actually going to the college and learning the things practically. If you want to be in your home country and enroll in these universities, and you want to have a CPT while in your home country, you don't need a CPT, you can work anytime. That's not a problem at all. But if you are in United States, you're supposed to go to college. That's the whole purpose why student visa has been issued. If you were to learn distant learning, you can be at your home country. Now, these things when we are telling, a lot of students are not following the directions because it's easier for them to get a CPT, but we need to make them understand that it's not that even though you might be getting a temporary benefit, there is a greater chance that you will be in big trouble later on when you get the H-1B. Even further after you get the H-1B also, they can still come back and count your undocumented stay. Now, Emily, in the August 9th video that you presented, you did cover the CPT though. Can you explain that how these people who are obtaining the CPTs, this August 9th memo might retroactively be effective for them, and it might be a grave danger for them?
Yeah, so let's give an example here. Say you have a student who is starting a new graduate program September 1st. When we're in the fall, it's back to school time. Right. So you're starting your program and you're at a school that allows day one CPT, even though that's not a proper term. They allow you to have CPT during your first year of studies. So starting September 1st, you are approved for CPT and you're working for your employer 40 hours a week and going to school at some point, I don't know when, but you're taking maybe one course, because I see a lot of these schools, they claim that full-time course of study for their school is 6 credit hours a semester. 3 of those credit hours are the CPT class, so they're really just taking one other class.
3 hours is only one class.
Right, exactly. So they're taking one class and working 40 hours a week. That starts from September 1st. Now let's say their employer sponsors them in the H-1B lottery on April 1st, so they're going to request a change of status from F1 to H1. USCIS selects the petition in the lottery, and maybe they're slow next year, so maybe around October 1st of 2019, they start looking at this case and issue a request for evidence stating, show us that you have completed a full course of study and show us that your CPT was properly issued. Show us that it was integral or essential to your program. These are all RFEs that we see day in and day out. So we're getting that RFE on October 1st, 2019, over 365 days after this person started their CPT program. They've been working full-time on CPT the whole time, and they've been taking one course a semester for the last year. Now, we respond back to the RFE, provide them all the wonderful letters that the school provides and the DSO provides and the registrar provides that really don't answer the question as to whether this is required for immediate participation. They just say it's required but don't explain how or why. They don't explain why immediate participation is necessary, why they don't make someone wait for 1 year. They just say immediate participation is necessary. So you reply back to the request for evidence. USCIS gets around to it maybe in November, and they look at everything and decide, you know what, this CPT was not properly authorized. You're using the CPT as a way to work, not as a supplement to your education. Therefore, it is a violation of your F1 status. Therefore, they're going to deny the change of status from F1 to H1. Okay, no big deal. The H1B itself can still be approved. You just won't get the I-94. Now comes the problem. When you get a denial of the change of status because of a status violation, under the new August 9th memo, USCIS will count unlawful presence not from the day of denial. They're going to count it from the day the violation began, which in our example was September 1st, 2018. This decision came on November 1st, 2019, which means our poor student has spent over 365 days unlawfully present in this country. Now they have this wonderful H-1B approval notice that they're going to exit the country and go for visa stamping, and at the consulate will say, sorry, you're barred for 10 years because you stayed unlawfully present for over 365 days. I hope the CPT was worth it.
Now, it has become very important, as Emily has pointed out, that the dangers of the CPT is much higher this year as compared to the previous year, because before August 9th memo, when a change of status was been denied because the student did not maintain the legal status, it was only counting the unlawful status from the time the status has been denied. So what Emily was pointing out, the 360 days would have started from the time the denial came in, but in light of the August 9th memo, it's counting going back to August 9th or the day it's been violated. So that's the reason the 3-year bar or 10-year bar are more effective now than compared to the previous years. We did got a lot of denials of the change of status and got their H-1B approval in 2016 and 2017 for the same reason for which Emily was speaking. But the consequences of that was quite different. They went to their home country, they got their H-1B visa stamping, they were not barred in applying for the visa application again, and they were allowed to come back into the country. In light of the August 9th memo, as Emily was pointing out, you have a 10-year bar because you were on the CPT. Now, if you were to apply for any non-immigrant visa or any immigrant visa, you need to apply for the waiver of the 10-year bar. It's a whole different area. We are not covering that right now, but that is now being required, what was not required before August 9th. And that's the reason we want to emphasize more, and we are presenting this video so that people need to be aware that it is quite different last year than that of this year.
Right, so just because your friends did it last year and didn't have any problems, it's a completely different ball game. So don't rely on someone's anecdotal story from a prior year saying they had no problems, everything went through great, because this memo changes everything.
Now, Emily, coming to the memo point of view, now if some people would like to correct, let's say for example, if they are on the CPT right now, can they now correct it going to the regular school, not taking the CPT? Will it be fine? Or do they need to take any other action? Does the undocumented stay start counting from August 9th and will keep on going on even though they stop doing this activity?
Right, so even if you later come into compliance, Once you're out of status, you can't get back into status by coming into compliance. The only way to get back into status after you're out is to exit the country and come back in. So for those that are thinking that moving to a PhD program or maybe moving to a different program at a different school and not taking CPT is the answer to all of your questions, that by itself is not enough. You also have to exit the country and get back in F1 status to go to school in your new program and then comply from that date going forward.
So practically, if anybody was in the CPT program ever, even before August 9th, it could be ruled that they violated the status, and if they don't exit and come back into the country, the entire period will be counted as an undocumented stay.
Right.
Is that right?
Mm-hmm.
Now, however, before you take any action on that, we would request that you need to consult with a lawyer. What are the pluses in exiting? What are the risks associated if you stay in this country? Don't take the decision by yourself. It should be more individual. Please consult with a competent lawyer who is going to describe what are the risks if you go outside the country, what are the risks if you stay here at a later state. So even though if you were on CPTs that are murky CPTs, let's call that, or not so good CPTs, now if you should check with your lawyer if you have to exit or you want to stay and continue not going into CPTs. Now, this is not applicable, a lot of people come to the question, is this applicable for those people who are going to some good universities and they completed their first year of their master's degree and they did the summer CPT? Are they fine?
Right, yeah, in that situation, most likely that CPT was properly authorized. So as long as you complied with all of the requirements, attended the school like you're supposed to, you didn't work too many hours more than what you should have, then you should not have any issues to worry about with the CPT that we're talking about right now. Now, one issue that does come up with the CPT that you discussed, where you went to school your first year and then you do a summer internship, is how does that impact the OPT after you graduate? There have been issues, and we've had cases like this as well, where USCIS sent a request for evidence saying you've already used 3 months of CPT time, therefore you're only eligible for 9 months of OPT. How is it that you got 12 months? That has been successfully responded to. We've been able to explain that the restrictions on only 12 months of practical training have historically only been applied to CPT after OPT, not CPT before OPT, if that makes sense. So in the situation that we've described, they should not be subtracting your CPT time from the OPT time. The restriction from CPT to OPT is that if you do 365 days of full-time CPT, full-time meaning 20 hours or more, that means you're not eligible for OPT after you graduate. If it's less than 365 days, you're still eligible for full 12 months of OPT after you graduate, as long as the CPT was properly authorized.
Emily, there is some confusion because of your articles that you present in the Immigration Girl and a couple of the videos we have presented. And then I have seen your article that you published that same level degree, CPT, is not allowed. Is that the title that you used?
I think so.
I got a lot of questions on that, that's saying that, well, now I'm going to go to doctorate degree instead of master degree. Is the day one CPT allowed in there when I'm going for doctorate degree?
Well, again, there's no such thing as day one CPT, and even if you are going up a degree level, you still have to meet the 1-year requirement before you're eligible for CPT. I think it's very rare for normal schools to allow someone in their first semester of a PhD program to work 20 hours a week. That would be very unusual. I mean, a PhD program, I was in one before I went to law school. It was hard work just to get to the classes and study enough to be able to keep your grades up. I don't know how anyone could work during their first semester of a PhD program.
Well, maybe you went to it. These are different schools. They don't conduct, they don't even go to college, some of this. Yeah. So it's quite different. So yeah, don't take the misconception that just because Emily has said that same level degree CPT is not allowed, doesn't mean that if you go to the next level, CPT is allowed. Don't take that one. Every CPT, they have to do the first 2 semesters, and then they will be eligible. Now the rule, what was pointed out, is same level OPT is definitely, same level degree OPT is not allowed. That everybody knows. But at the same time, it has nothing to do with same level. It has to do with whether you have completed the first 2 semesters before you get the CPT. That's more important.
Yeah, so that was one of the questions that popped up, for someone who's finished their STEM OPT, didn't get selected in the lottery, is it better to do a master's with day 1 CPT? Is it better to do a PhD for day 1 CPT? The answer is neither. No day 1 CPT. It should not be given during the first year of any program.
It doesn't matter whether you're going to hit yourself with a marble stone or granite, you're going to hurt the same with the day 1 CPT. We definitely advise people not to take the day 1 CPTs. You're going to be risking. Emily, having said that, is there are some changes in the STEM extension where the USCIS website said something, and then of course we did present it something, and the next day we just completely reversed it. Is there a possibility that this is an interpretation of, or is it the regulations are very clear in this one?
Yeah, on the requirement of 1 year of studies before CPT is authorized, that's very clear in the regulation, word for word. For any practical training, student who it's authorized for students who have been lawfully enrolled on a full-time basis for 1 full academic year. That's it.
If ever you're forgetting about all the rules and regulations that you probably might not be that familiarized with, never forget that the student visa is being issued for you to come here to temporarily study and obtain a degree, and because the degree value will be higher if you return back to your home country, if you work a certain period of time on a practical training or a curricular practical training, that will enhance your degree. The purpose of the student visa is for you to obtain the degree and probably enhance the degree by getting some extra training. The purpose of the student visa is not to have a work authorization and work in United States. If you want to work in United States, if the purpose is that, there are different kinds of visas. F1 is not that visa. The F1 is not a work visa. It is a student visa. Never forget that. One thing is that, Emily, is that, oh, I don't know all these rules and regulations. It's very complex for me. Can I get an excuse because I don't know the rules and regulations?
Definitely not. If you're speeding in a school zone and you didn't know it was a school zone, you're still going to get a ticket, regardless of whether your intent of doing it on purpose or not. That doesn't matter. So even if you don't know the rules, you're required to abide by them. So you don't think that you can use that as an excuse to not get in trouble with that.
Praj has this question. The STEM OPT expires on September 10th. RFE has been answered. If my H-1B is going to be denied, should I go to the second master's with a different and get the CPT? Can I do a PhD with a CPT or return back to India and try my luck again in 2019? If you want to stay in United States and you want to continue going to the school, yeah, you can. But day 1 CPT is not the way to do it, because day 1 CPT, we believe, is more like a work visa kind of thing, which we're not allowed to on a student visa. But I think so. I am very much leaning for you. If you get a H-1B denied, don't look into CPT. This will have negative consequences down the line, even if you don't think so at this point of time. They will have, particularly after the August 9th memo, you should not choose the day one CPT. Go to India, try your luck again.
Vinay has this question, if someone has the day one CPT and they have an RFE right now on their H-1B, can they convert to consular processing? And if yes, are they still going to have a problem when they get the visa, particularly if they don't depart the United States before February 4th? Why do I mention the day, February 4th?
Okay. One thing is that it might be a good strategy, legal strategy at this point of time, to have your lawyer choose the consular processing, because if the USCIS determines that you are out of status by working on CPT, as you rightfully pointed out that you got the RFE on the CPT issue, if they negatively decide, then you go to the consulate to apply for the visa. Now, I will explain about the February 4th date afterwards though. Now, once the USCIS determines that you're out of status, and then you go to the consulate will have a very negative look at your H-1B application. That's one of the reasons why we recommend you to not go for the consular processing. As Emily pointed out, that everybody has to remember the February 4th, 2019. The reason you need to remember is that if you are in a CPT on or before August 9th and the USCIS determines that you're out of status, the undocumented period counts from August 9th onwards. If a person is not documentarily present in this country for more than 180 days, you have a 3-year bar coming into United States. In other words, if you get the H-1B approval, you go to the consulate will say you have a 3-year bar, you need to apply for the waiver before you come in, or apply for the H-1B visa after 3 years. Your job won't be there for 3 years for sure. H-1B won't be valid for more than 3 years anyway. So that's the reason why we recommend that you go for the consular processing. Any other additions to what I said, Emily?
No, I would agree with that. One of the questions I think we already covered, but we'll just kind of go over it again, is if someone's already working on the CPT that may or may not have been properly authorized, what should they be doing right now?
I think so they should check with their lawyer to see if first is they need to discontinue. The second thing is that by discontinuing it, it's not over yet. They still might have to check with a lawyer to see the options. One of the options probably will be that they will go outside the country, get the stamping, and they will visit outside the country and come back. That might cure it, but they need to check with their lawyer on that, Emily. Any other things that are coming up?
Just a reminder, for this particular Facebook Live, we're only discussing CPT, Curricular Practical Training, right now. So I've seen a few questions of not related topics. For those questions, feel free to join us on Tuesday. That's our normal Facebook Live where we answer all topics on immigration. This particular one is only related to the CPT.
Jignesh have completed master's degree in computer science. Can he go to the executive MBA and get the CPT? The question is he wanting to get the CPT immediately, can you answer both the questions?
Yeah, the first issue is an executive MBA is a master's degree, which is at the same degree level, so that's not going up a level. So if you've already used up all of your OPT time, the only way to get additional practical training of any type is to go up to the PhD level. Staying at the MBA level won't be enough. And then on top of that, we would not, again, recommend any type of practical training during the first year of whatever program you choose.
Surya has this question: have you been successful in getting the H-1B approval for a person who has done the CPT after the first year is completed and then completed 12 months of OPT?
Yes, we have successfully received approvals of that, even when we had requests for evidence on that exact issue, questioning how a 12-month OPT was issued when you've already used up 3 months of your CPT time. Again, historically, that restriction on 12 months of practical training has not been applied to CPT and OPT combined when the CPT is after the first year of study. That restriction is in the event that you use 12 full months of CPT, then you're not authorized for OPT. Anything less than the 12 full months, you're still eligible for the full time of OPT after you graduate, as long as you haven't received a degree at the same level where you've already used up your OPT time.
And also I want to take the opportunity, Surya, that I don't think so we have any denials if that was the issue. Am I correct, Emily?
That's correct.
Yeah. However, to say, Surya, is that we had string of denials, a lot of denials of the change of status when the person was on CPT after they're completing their EPT, and we have also have denials for the day one CPTs. And these denials are growing day by day, and the questioning of those things are growing day by day. Now, even though we had denial previously, we were able to get those people on status back successfully, but I don't think so we can do it starting from February 4th of 2019.
Yeah, I definitely agree with that.
I've been working on CPT from last October, but my coursework started last January. Should I be fine on that? January is the start date of the school, and he started CPT in October.
Sounds like that's not one full academic year.
No, it looks like, for me, if you count
Maybe if they
August,
count the summer.
September, I counted it, it's actually 10 months. So yeah, it looks like he completed 2 semesters. Yeah, it's most whether you completed the 2 semester of classes. If you've done it in January, yeah, I think so. It looks like they might have completed 2 semesters. But the question to be asked to you back is that have you completed the 2 semesters requirement? Year doesn't mean 1 year. Emily joined her law school in August. She started working with our office in May, which is not actually the entire year. And that's fine if you completed the 2 semesters in your college. But if you did not complete 2 semesters, then I think so you are in a question mark, that I would say. If you're in CPT.
Have you seen any, how to put this nicely, any normal schools issuing CPT during the first year? When I say normal, I'm talking about household name type schools that everybody's
University of
heard of.
Houston, UT Austin, University of Denver, University of Arizona, not just Harvard, Yale, of course we count them too, University of Massachusetts, University of Chicago. No, they don't issue day one CPTs. And it's only some universities, I think so only a dozen of those universities that are issuing day one CPTs. So please remember that, if you ever forget that, about 99% of the universities don't issue CPTs, day one CPTs.
Right, so that should tell you something about the program that maybe you're considering entering. I know it sounds, if it sounds too good to be true, maybe it is, the old saying.
I would say that in the US news, if you go to the top universities, I don't think so any of top 100 universities issue, top 100 universities, none of them issue day one CPTs. One question is that I am in CPT, but the USCIS issued an RFE indicating that I am on OPT, and they issued an RFE. Should we still answer responding to the maintenance of status of CPT? Yes. Even if the USCIS has mistakenly said that you are on OPT while you're in CPT, once the maintenance of status has been questioned in the RFE, I want to take the opportunity to explain and answer everything about the maintenance status. I do not want to leave any door, not everything need to be clearly defined and answered. Don't leave any stone unturned when you're responding to the RFE. Just, oh, I'm not an OPT and respond to that. No, you need to say that you are an CPT, make your arguments and try your luck. And probably, as we pointed out before, may want to avoid that argument and go for consular processing completely.
Rupika has a question. Where did it go? Can someone who already has a master's degree in the U.S. join a second master's degree just in general? Nothing to do with CPT. They're not planning on using CPT or OPT. Is there a problem with doing a second master's?
Absolutely no problem. There are a lot of people that do second master's degrees. Absolutely no problem. There are many graduates who have done second master's. Absolutely, you're good. It's just the day one CPT that's an issue that we're discussing. Doing second master's is not an issue at all. You don't need to go to the USCIS to get the approval. You can switch from one university to another university, changing the service system. It's not going to be a problem.
Does the reason why you're doing day one CPT matter at all? Are there some where, one of the questions is, my OPT STEM extension got denied because I filed it late. So because of that, I had to do the day one CPT. Does that make it okay?
Emily, if there are situations where people STEM extension was being denied for various reasons, and one of the things when their day one CPT was being denied, they're getting kicked out of the service system, and they have 60 days to go to another university to join. No, day one CPT is not allowed in those situations. Absolutely. Let me ask you questions so that I want to summarize all the things I want you to answer. Is the day one CPT allowed? I am doing first master's degree, never done any time.
No, not during your first full year of academic study, no CPT allowed.
I am doing a second master's degree, is the day one CPT allowed?
No. If it's during your first full year of academic study, CPT is not allowed.
I am doing doctorate degree, is the day one CPT allowed?
No, if it's during your first year of studies, it is not allowed.
Also, some things that the people who are on H4 visa, the people who are on H1B visa, Emily, where they lost their jobs, I have seen them applying to the universities. Their status is not even an F1 visa, and they applied to the universities. They got their I-20s. They applied for the change of status. Before the change of status, they started working. Is that legal?
Definitely not. Especially, if you're in H4 status, unless you have an H4 EAD, until you're actually approved for F1 status and then receive proper practical training approval, you can't work. It's just not allowed.
Is there any circumstances that you can imagine that the day one CPT is legal?
No. There are, schools that try to make it into the exception of the 1 year requirement by saying immediate participation is required. In order to say immediate participation is required, that really means it's required for all students just to graduate from that program. They have to do this program in the very first year. I think that that's very unlikely. Again, we don't see it at any of the household name schools, which should tell you something. And I would question whether those schools that are saying they do require it have any American students that are also being required to have that same internship. I think that most of the schools
they don't have any.
Catering towards
only
international students and then creating this CPT specifically for them. That's not what this is supposed to be. It's a program of study. If you go look on their website in their course catalog and look at what are the degree requirements for me to graduate in this program, somehow I can never find CPT as a course that's required to study. But why is it they're able to give day one CPT and claim that its immediate participation is required. It's not required. They're just saying it is when it isn't actually.
Emily, this question arises because I am in the community much more than you are, and we get to blame that how come hundreds of thousands of people, or maybe 50 or 100,000 people, were being issued day one CPT, and your firm is telling that it's not legal mostly.
Well, our job is to look out for our clients and make sure they don't do something that's going to get them in trouble. So, I'm going to do what's in the best interest of the person that's asking me for legal advice and tell them these are the ultimate consequences of the actions you're about to take. Regardless of whether 100,000 people did it before and were fine, what I always remind them is that the captain of the Titanic also had traveled across the ocean hundreds of times and never hit an iceberg, yet the Titanic still sunk. So,
and one thing that I want to tell the audiences of the REDDY NEUMANN PC who have been coming and watching very carefully, this acquisition has come many times on our law firm that in the CPTs we have been advising people not to. One simple question I will put back to you: don't forget that 99% of the universities are not issuing the day one CPTs. It's only less than 1% of the universities are issuing the day one CPTs. That should give a little bit guidelines to you where you are heading if you are contemplating on taking the day one CPT, if you are using the day one CPT, if you have used the CPT, day one CPT. You need to check yourself very carefully. And also, in light of the August 9th memo, we feel at REDDY NEUMANN PC that it's essential to put this forward to the students, because before August 9th memo, when and if the change of status would be denied, the negative consequences were not as bad as they are starting from August 9th, which actually going into effect on February 4th of 2019.
But what if it's part-time CPT from day one?
No. No. No part-time CPT on day one. After you complete the 2 semesters, then that may be proper. Anything else we have?
I think we've hit all of the questions and covered all of the topics that I can see.
One second, I'll check everything.
So while we're checking to see if there's any other questions that came up, if we didn't get to your question or if it's something not related to CPT, feel free to join us on Tuesday for our regular Facebook Live at 5 o'clock Central Time, where we answer all types of questions related to employment-based immigration. And if you want further discussion on your specific case, feel free to contact us to set up a consultation appointment. You can do that by going to rnlawgroup.com. If you want the latest news on immigration, practical news that you can actually use, not just the theory, check out immigrationgirl.com. That's my blog where I post updates on what's actually happening without all of the fake news hype and scariness that's out there in the media. So if you want to know the real information and how it's actually going to impact you, check out immigrationgirl.com. Any other questions?
Altmarsh has this question. What is the best thing to do? His H-1B has been selected, but he's on day one CPT.
Well, I would probably first recommend stopping the CPT, but then you're going to need to discuss with your attorney about whether travel at this point is the way to clear that up. And I would also probably look at upgrading to premium processing as soon as it's available. We're expecting September 10th it should be back, but we haven't had an actual announcement yet. But you want to make sure whatever you do that you take some action to get the decision by February 4th, no later than that.
Jignesh has this question. My STEM extension is expiring and you're telling not to go on CPT. If I go to a student visa and not take the CPT, can my employer file a H-1B if I'm not on the day one CPT?
Absolutely. That's a great question.
Yeah.
Your employer can file for you even if you're outside the United States. There's absolutely no reason that you need to be on CPT or even on OPT or even in the United States to file an H-1B petition. It can always be filed consular processing. As long as you're maintaining your current status, you're always eligible for the change of status.
Today we restricted our comments just on the CPT. However, as Emily was pointing out, every Tuesday we come and we have all general questions at that point of time. You can post the questions. You can post in advance in REDDY NEUMANN PC. We'll get to the questions and then we will address those questions on Tuesday. Anything else, Emily?
That's it. Thanks for joining.
Thank you guys for coming in.